So what is mediation and how can it benefit you? If you're involved with any type of dispute, it could be a legal dispute in the court system, it could be a divorce, it could simply be an argument between you and a neighbor over a fence or a tree or something simple like that. Mediation is an extremely valuable way to reach a solution without having to go through a formal, complex, and expensive court process. Look, as licensed private investigators, licensed insurance agency, we have seen firsthand what a court litigation can do, even for the winning party. It saps time, it saps resources. So mediation is a process that it's an opportunity for people that are having a conflict to reach a mutually beneficial solution with the help of a third party. And that third party is a mediator. Third party has to be an unbiased, impartial facilitator of the conversation. They're trained to help people resolve disputes. Look, in most cases, the dispute is happening because of emotions. You cling to an idea or a belief that you're right and the other person's wrong. A neutral mediator does not take sides, and the mediator does not make a decision for you. You're not bound by a mediator. It's not like a court process or even arbitration, which is different. The mediator helps the parties communicate by listening to both and help you see the reality of both sides. Sometimes it's difficult to hear parts of your argument that are maybe not as valid. But by listening to both parties separately, the mediator can see what the nature of the underlying dispute is and then suggest to the parties what might be a resolution that could be better than what a court would decide. Sometimes when a court decides something, it's bad for both parties. Even if it's neutral for both parties, you have attorney's fees and you have to spend months or sometimes years attending hearings, depositions, and it might make you feel good to plead your case and win your case, but the chances aren't 100% you're going to win, even if you believe you're correct. And even if you do, the principle or the pride that you win is usually not worth the cost. So the mediation process is a structured, organized set of events. Usually the mediator will talk to each party separately in advance of any mutual conversation. They'll listen to the facts, maybe do some research about the fact. It's what's called a party-centered process. It's focused primarily on the needs and interests of the parties, and sometimes the rights. One of the things that a mediator will do is what's called reality testing, seeing what is the reality, what are the facts of the case, not emotions, and keeping detached from giving advice, detached from saying things like you should do this or you must do that. It's an alternate resolution between the two parties, and a lot of times it illuminates the parties into possible solutions that might never have been considered by the parties. Mediation can fall into a couple different categories. It could be pure legal. It could be something that the court requires before you start litigation. Sometimes it's diplomatic between two administrative parties. Sometimes it's workplace. You may have a dispute with a coworker or a manager. There are community mediators that get into things like how a school system might affect the community. There's family mediators. They get into divorce or child support or other types of cases. It's any type of instance where a third party facilitates people in conflict to reach an agreement. There's usually a structure, a timetable, and a series of activities that is private normally confidential, it's usually not enforceable by law. Usually the participation is voluntary. Sometimes a court will require mediation before there's a court case. But usually it's just a recommended process. In most cases, the mediator can't say you should do this. They may have a suggestion. They may tell you, in our experience, this is what we see will happen if you go to court. But that neutral third-party point of view makes it easy not to take sides. No matter how personal your conflict is to you, to a mediator, it's just two people in dispute. And what it will do is it will give you an insight into what a judge or a court is going to think. One of the things we found in many years of attending court litigation in various aspects, both as an investigator, as an expert witness, even as a principal in cases, even though your case, the way you look at it, is cut and dry, black and white, clear cut, you don't have any doubt, the other party feels the same way. Otherwise, they wouldn't be going to court. One or both of you might be wrong. One thing that I can guarantee you is when you go to court, when the judge looks at both parties, the initial opinion of the judge is everybody's wrong. Judges in courts, even if it's subconscious, see so many people fighting amongst themselves, arguing, disputing, many times over ridiculous facts or ridiculous issues in the eyes of the court. To you, it's very serious. To your counterparty or whoever you're disputing against, it's a very serious thing. But to the court, it means nothing. It's not part of their life. A lot of times they look at it like, why are you fighting over this? In fact, I'm sure you, as an observer, have seen news articles about people fighting over something as stupid as what color to paint my house, or can I grow a bush 3 feet or 4 feet in my yard, or something stupid. The judge is going to look at your case the same way, 9 times out of 10. Judges see thousands of cases a year, and most of the time they look at it as people who just can't get along, and they're unreasonable. They look at it like anybody who makes it to court has been unreasonable and able to settle their differences outside of court. And they are going to look down on the parties initially. That's going to be their default. Now, they may find that obviously one of the parties is honorable and the other one is being, unreasonable. But it's going to take them a while to get there. And sometimes they never do. So having an arbitrator or a mediator do a process before court will give you an insight into how the court's going to look at this. They will do it also with the benefit of trying to help the parties come to a conclusion. In most cases, a judge or a jury, they're not going to try to help you reach a conclusion. They're just going to do the least possible denominator of a benefit to one or the other. And most times it's going to hurt both parties. A mediator, on the other hand, will have empathy to both parties. Look, I wish you didn't have to go through this. I'm trying to make this easy. I wish you didn't have this pain. They're aiming to help the parties reach an agreement. The skill of the mediator is in having an open dialogue, improving the communication, not pointing the finger, not casting blame. That procedure of discussing the facts with the parties takes patience and persistence as a mediator. You can't give up. You have to stick with it. Even if the parties want to give up, you have to stick with it. You also have to have common sense and some knowledge of court systems to know what's going to happen in court if it goes there. It's partial negotiation. It's partial human dynamics. You have to be smart. You want your mediator to be have empathy towards parties, to have emotional intelligence in addition to intellectual intelligence. You have to listen effectively, and that's what you want, isn't it? As a party to a conflict, you want somebody to listen to you. In most cases, that's the nature of a conflict. The other person's not listening to you, not hearing you out. Sometimes just having yourself heard is 90% of the battle, and having the other person hear you out might solve the problem. Usually the mediator has no power to render a resolution, but will help create a solution facilitated by the mediator's guidance. Why would you choose a mediator over litigation? Well, we talked about cost. There's some other advantages. In most cases, these are private. It's not in open court where it's public records. You can talk about things that you may not want to reveal in court. You can also preserve the relationship between the parties because there's a go-between. Think about this. A real estate transaction on a house usually results in a commission to a broker of $30,000 to $40,000 to $50,000 on average. Why don't two people buying and selling a house just connect together and do their own deal? The reason why is having that third-party buffer in between helps people from getting offended, from having to be too confrontational, to having things be too upfront and personal. A mediator helps do the same thing with a conflict. It puts a buffer in between. It makes you not have to be face-to-face with your opponent. You have somebody in between that's helping facilitate it. The conversations are normally, like we said, private, unless there's some violation of law that has to come out. Attorneys can also benefit from this because, look, attorneys don't like to litigate cases that are going nowhere or that are ridiculous. You might think, well, attorney likes to do billable hours. Yeah, they like to bill hours, but they don't like to bill hours for things that are not beneficial to the parties. It's monotonous to them. It's an opportunity to improve the case for the attorney. So even if it does go to court to litigation, the attorneys have already had some melting of the ice between the parties. It can help the parties recognize what might happen in court and maybe smooth the process. Usually, mediation starts with the mediator talking to the parties individually, then maybe a mutual neutral place where they all get together. Nowadays with video conferencing, whether it's Zoom or Google Meet or Skype or something else, you can do it separately. That also puts some distance. If there are attorneys in the case, sometimes they're present as well. You can have third parties in the case if it's agreed upon for everybody. A mediator can also maybe generate an opinion to say, look, this is what I think. Usually there's no penalty for not reaching or settling a case through mediation. It may be court ordered to try, but it's usually not a penalty if you don't get anywhere. It's just to help facilitate the process going to court. What else can a mediator do to help solve the problem? Well, they can be a voice of reason when one or both of the parties are not being fair, or not playing fair, not talking fair. The mediator doesn't decide what is fair, but they can throw some water on the fire, so to speak. People's emotions sometimes get the better of them. And a mediator with no stake in the outcome can very easily help people walk through and navigate through that process without having to be confrontational. What is the cost of mediation? Very, very inexpensive. Usually mediation can cost a few $100s for most cases. So even if it's $1,000 or $2,000, it's much less than 3 or 4 hours of billed hours with your attorney. And it can go a long way to help exchanging information to move your case forward so that you can avoid litigation going to court. Because once you go to court, what the judge or jury decides is final in most cases. Yeah, you can appeal, but it usually doesn't work. Give you an example of a case that would have benefited from litigation, from mediation. It was a case over a contract that was in the amount of $11,000 contract. It had to do with some business services that are provided from one business to another for $11,000. And there was a dispute over the services. One party that was getting the services felt like they didn't get what they paid for. The other party said, we gave you more. In fact, you have to pay us more than the 11 because we did more work, even though that wasn't in the contract. So they sued him for $30,000. Went to court. They did depositions, and this case dragged on for over a year with hearings and all kind of legal activity. Each party paid over $100,000 in legal fees. Each party. It was almost $250,000 in legal fees altogether over a $11,000 contract. The party that won, fortunately in the contract, the winner gets reimbursed their legal fees. So the party that won was reimbursed for their legal fees. So you would think, well, at least they came out okay. Well, they didn't. Obviously, the party that lost was out $200,000 of legal fees, plus they lost the case. The party that won still had about $15,000 in legal fees that weren't covered by the contract because they were claimed to be outside the scope of what was agreed to. In addition, the party that won had to appear in court 6 times over the course of a year and a half, had this potential loss hanging over their head of tens of thousands of dollars, had to worry about it, distracted from their business, and was out the money for a year. They had to pay those legal fees throughout the course of a year. At the end of the case, they got it back, but they basically gave a free loan for $100,000 plus and got some of it back at the end. So even in a case where there's a adjudicated result in a case of judgment or finding, even the winner really doesn't win. Even if you have the ability to get reimbursement of your legal fees, a lot of times you don't get it all back because there's exceptions to the fees. Sometimes court fees don't come back to you. And you have that risk of loss. Look, we've all known high-profile cases where you would think, hey, this person's guilty, they should go to jail, and it's a high-profile case, a celebrity, and they're found not guilty. Juries can do anything. They can find against you even if the facts are clear-cut in your opinion. A mediator can help you avoid all that and get a settlement. Sure, any case can settle without going to court. The problem is if the only people who are working on trying to negotiate with the parties are the attorneys, it's not going to help facilitate a settlement because the attorneys, even well-meaning, even attorneys that don't want to just bill a bunch of hours and go to court, are going to have a difficult time dealing with a counterparty because they have a stake in the case. They're trying to argue for you. They may not be able to disclose everything. They may not be able to neutrally have a legitimate argument with the other side because the other side's going to say, well, you're just saying that because you want to win. Where a mediator is completely unbiased, completely neutral. In fact, if a mediator finds that they have some conflict of interest or an opinion, they have to withdraw. Mediator can help avoid all this for a reasonable amount. And there's mediators everywhere. Every state has them at every level for every type of case. Even if it's just a small issue between two parties, it would never go to court. Two neighbors, two people on the PTA board, two people on the softball team that just can't figure it out. Spend a few $100, have a mediator jump in. It can also save friendships before things are said that can't be unsaid. And mediation is a frequently overlooked, valuable tool in resolving any conflict. Business relationship, personal relationship, marriage, community, anything can be helped with mediation. In fact, the reason why many courts require it before you go to litigation is because they know the benefits are there. They're not trying to keep a case out of their courtroom. They're trying to put that benefit in the mix for the parties.